Thank you very much. So the Neutrals Nook, what we do here is just a place to raise awareness and understanding of ADR methods. That is alternative dispute resolution methods across various jurisdictions. How is this being practiced? How can we improve on our own practice? We share expert insights and real-world experiences relating to ADR, support continuous professional development, foster collaboration across jurisdictions, and promote diversity and access to ADR. That is, in summary, what the Neutrals Nook is about. So today's topic, which we all know, is episode 3, medical negligence and alternative dispute resolution. Patient safety, accountability, and ADR. Can all three coexist? I wouldn't be saying much on this topic. The moderator will introduce the speakers when we get to that time on our agenda. But right now, I would like to introduce to you all a new segment of the Neutrals Nook, which is called Inside the Nook, seeing through the person behind the neutral. In this segment, we're going to be interviewing and speaking to experienced ADR professionals. They would share from their wealth of knowledge on ADR and their practice, the do's and don'ts, on ADR and other things. And we're going to be releasing the first episode very soon. So I would like for you to please subscribe to our YouTube channel, The Neutrals Nook on YouTube. We're going to be dropping the link in the comments so that you can just click on subscribe to get notified when the first episode is released. Now we'll just it will play a short teaser of what that episode would look like. I'm sorry, there's no audio. Let me play. Let me share it again. There's no audio. Okay. So.
It is possible that at all times you come in as a mediator all the time in the lives of people where there are differences. And so the first time I got on that seat, I had a feeling that I must succeed. As a mediator, you are not there to solve their problem. You were merely there to help them solve their problem, and that they were going to solve their problem themselves. Because it is when you go there and you pose as a judge that the parties will begin to misunderstand you. Several years afterwards, you forget the people. Then you get an occasion. Somebody walks up to you and reminds you of the case. It gives you so much joy. It gives you so much joy. And in fact, at that point, still congratulating you for what you did.
Okay. So we had the privilege of interviewing Pastor Engineer Wigwe. He has over 20 years experience in mediation. He's 92 years old now, and it was a very interesting interview. So I would encourage everyone to please subscribe to the YouTube channel. We'll drop the link in the chat so that you'll be able to join.
It is possible that...
So we'll be moving on. I'll be introducing our moderator who would take over from here. Her name is Ayonfe Oluwa Aino. Thank you, Ayonfe. The floor is yours now. Thank you very much.
All right. So good morning, good afternoon, good evening, wherever it is you're joining us from. My name is Ayonfe Oluwa Aino. I'm a lawyer in equity and a legal officer at Dukia Investment here in Lagos, Lekki, Nigeria. And I'm really honored to be here today moderating this discussion. Welcome once again to episode 3 of the New Trust Nuke. This episode is titled Medical Negligence and ADR, Patient Safety and Accountability and Resolution. Now, before we dive into the legal or medical or emotional layers of today's discussion, let's just do a little bit of exercise, right? So raise your hand. You can raise your hand virtually or you can use the emojis. Raise your hand if you've ever been at a hospital waiting room, either for yourself or for a loved one, and you just wondered, what if something goes wrong? Who do I hold accountable? What if something goes wrong? How do I find fair resolution? How do I get, a fair resolution for what has gone wrong? Now I can see some hands are already being raised, and that is because every one of us at some point in time would have had to use the services of a medical practitioner, and often sometimes, or let me just say sometimes, medical negligence occurs in loss of life or loss of limbs or even in further complications. Now, if we've all had that moment, that makes today's discussion really, really important, and not just important, but necessary. And today, we'll not just be talking about laws or procedures or cases, no. We're talking about a system of resolution that can prevent harm and can also help us to achieve fair resolution when conflict occurs. And that is why personally, I think that ADR has become a powerful bridge that can be useful to resolve emotion-laden conflicts that happens in medical negligence. Because ADR, as we can see, can look beyond the blame. It can look beyond litigation and can really, really address what the issues are. So whether you're a doctor or you're a lawyer or you are an ADR practitioner that is looking to resolve issues for people, or you're a lawyer that wants to get justice for families, or you're a medical practitioner that wants to protect your practice and also wants to put your clients first, you are in the very right place today. You're in the best place you can be today at the New Trust Nuke. In today's webinar, we're going to have 2 established professionals speak to us for 25 minutes each. And then after that, we're going to have a moderated discussion between the both of them. And then we're going to give an opportunity for the audience to ask questions. And then the webinar will come to an end. Now, having said that, it is once again my pleasure to officially open today's webinar. I will be inviting and I will be reading the bio of the first speaker, and that is Dr. Olusegun, as she will be taking the virtual stage to make her own presentation. So I'm reading Dr. Olusegun's bio now. Miss Simi, can you project her profile while I read? Okay. So Dr. Olaitan Olusegun is an associate professor of law at the Obafemi Awolowo University, Ile-Ife, Osun State, Nigeria. She is an Africa Oxford Initiative, a visiting fellow at the, at the Bonavera Institute of Human Rights, University of Oxford. She is also an Alexander von Humboldt Fellow at the Max Planck Institute of Social Law and Social Policy, Munich, Germany. She's a co-author of a book titled Legal Prescriptions for Medical Practitioners, a handbook of medical legal issues and rights protection, which was published in 2023. Now, her research interests include health law and policy and child rights, with several articles published in both national and international peer-reviewed journals. So we can rest assured that we are being spoken to, or the person we have today is an established professional, who has done the legal part and also done the medical part extensively. Dr. Olusegun is currently the chairperson, Board of Trustees, Mordecai Care Foundation, a non-governmental organization in Nigeria, which focuses on empowering women, rescuing vulnerable children, and campaigning against gender-based violence. Ladies and gentlemen, please make welcome with a virtual ovation. Please just use the clapping emojis to welcome Dr. Olaitan Olusegun as she takes the virtual stage.
Thank you very much. Thank you. Thanks for having me. I also want to thank the hosts of this program, Simi Oweye. Thank you for all you do in the space of ADR. I can assure you that she's very diligent, and I'm sure Dr. Aigbe would testify to the number of mails that we have received ever since we got the invitation to present this important discussion. I also want to say thank you to Dr. Aigbe for coming today, for being present, and I'm sure I would learn a lot even at the program today. So I hope you can see my slides. I'll try to share.
Yes, we can.
All right. So let's start. I was told I have 25 minutes. I will keep to time. I'll try. I'm sure I will be able to keep to time. So we have a very important topic before us, medical negligence and alternative dispute resolution. This is a very important topic because we know how harmful medical negligence can be to people, and we know how important health is. So for starters, what people think is that, every time you go to the hospital to present a case before medical practitioners and something goes wrong, people just assume that the medical practitioner should be held liable for whatever it is that happens, right? But that is not always the case. That's not always the case. It must be proven that the medical practitioner or the healthcare provider, was negligent. It must be proven that the healthcare provider was negligent. And I must say that medical negligence is not only limited to medical practitioners. It's everyone is involved: nurses, pharmacists, radiologists, and so on and so forth. Everyone that works in the healthcare field is involved and could be held liable. But we just focus on medical practitioners most times because we feel, and well, which is true, they are more prone to medical negligence. So this discussion might focus a bit on them because, they tend to fall in that line more than others like nurses and pharmacists. But then sometimes I might also talk about other people, but I'm going to focus on medical practitioners. I just wanted to establish the fact that other persons in the healthcare field might also be held liable for one act or omission or the other. So like I was saying, it's not automatic that they'll be held liable once something bad happens, right? So they must actually they must have done something to, for people to say, or for the courts to be able to establish that they have actually done something wrong. They must have been negligent. And what is medical negligence? It is an act or omission by a healthcare provider in which the treatment falls below the accepted standard of care. And it must have resulted to injury or death of the patients, right? So that means that there is a standard of care that is expected from medical practitioners, and it must be certain. It must be certain that they are falling below that particular standard of care. So how do we know what the standard of care is? It is medical practitioners that will tell us. So when there is a particular case in court, for example, the judge is going to call a team of experts to come and testify as to whether they would have done they will have handled that particular case differently from how that medical practitioner handled it. For example, in Bolam versus Frying Hospital Management Committee, there was a particular therapy that took place for a mentally ill patient, and they did not give that particular patient drugs to relax his muscles, and he suffered from complications. And at the end of the day, when the medical experts testified, it was held that they testified that that was exactly what they would have done, because doing otherwise would cause harm to the patient. So, but then in Bolito's case, the court held that the testimony of the experts must actually make sense. So it's not automatic that such testimonies will be accepted by the court. It has to make sense. So it's not automatic, but the standard would be established by a team of medical experts. And then, of course, there has to be a particular injury. The patient must have suffered from one injury or the other, loss of limb, death, or any particular complication. And then some people could also prove that they had a traumatic experience that affected them emotionally and stuff like that. But at least you must prove that it affected you one way or the other. So there are many examples of medical negligence because these things happen. They happen, I don't want to say every day, but they happen a lot. And I'm sure we've heard of so many cases in the past few months that have happened. One example is negligence during surgical procedures. They happen a lot. An example is Irene Emmanuel versus Anthony Ewere. And in that case, the woman had a CS, and during the CS, some parts of her intestines were cut off. And of course, the doctor was held liable for that. And then sometimes they leave surgical instruments inside people. Sometimes they cut off what they're not supposed to cut off. Sometimes, different things happen. So that's just an example of the things that, could happen when surgeries take place like that. And then another one is improper or incompetent treatment of a patient. It could be incorrect diagnosis, it could be the prescription of a wrong drug. An example is the Orgis case, where a boy was wounded when he went to play football, and the doctor did not handle the case well. He put a cast on the leg, and the boy complained that the cast was too tight, but the doctor did not listen. At the end of the day, oxygen supply was cut off from the leg, and they had to fly the boy abroad. At the end of the day, the doctor was sentenced to 4 years imprisonment for 4 different charges, 1 year each for all the charges. This happened very recently in 2023. Another instance is failure to give adequate information. This is not a Nigerian case, it's an English case, Rogers versus Whitaker. The woman was supposed to carry out an operation on one eye, and the doctor failed to inform the patient that the other eye could be affected. And then the other eye was eventually affected, and the doctor was held liable for not giving the patient sufficient information, because probably if she knew, she would not have gone ahead with that particular surgery. And another instance is failure in obtaining consent. In this particular case, Dr. Afam Ezendigbo, the doctor conducted a CS without obtaining consent, and he claimed that he felt it was sufficient. Since the patient paid for the surgery, that was sufficient. But the court told him that no, it wasn't sufficient. You need consent, and it has to be written for surgical cases or any severe issue. The consent has to be written. And then there's also another instance is the failure to attend to a patient requiring urgent attention. And we know that this happens a lot in Nigeria. So there are so many cases, and it could be harmful to patients. Another effect is that it undermines the confidence of people in healthcare institutions and providers. So you find people going to traditional doctors or trying to self-medicate, and they do other things that will be harmful to them because they feel that, well, we don't know what will happen. If I go to the hospital now, I don't know if my case will be treated well. I don't want any issue, and then they do other things. So that is why it is important that we handle medical negligence appropriately. And when medical negligence happens, there are different redress options that will be taken by the patient. One is litigation. Litigation is filing a complaint in court and getting legal representation, or you could do it yourself. You could represent yourself, or you get legal representation, and then the court handles the case and tries to know what happened and stuff like that. And then another option is disciplinary action by professional bodies. So it depends on the particular professional body the defendant or the person that would be held liable or that might be held liable. It depends on the professional body he or she belongs to. So, for example, as a medical practitioner, such reports would be taken to or be handled by the Medical and Dental Disciplinary Tribunal or the council, which will be, so once it gets to the tribunal, there is a panel that would investigate first. They discover that, okay, this is tangible enough, they go ahead to handle the case. But then if it's for nurses, it will go to their own professional body and so on and so forth. And then the third option, which is the focus of this presentation, is ADR, Alternative Dispute Resolution. What is Alternative Dispute Resolution? It is a process in which disputes are settled without going through the strict procedure of the court of law. So there are many methods, there are many procedures. There's arbitration, mediation, negotiation, early neutral evaluation, among other methods. And the particular ideal method that is used, depends on several factors, depends on the knowledge of the parties, depends on whether they want to use legal representation, whether they have legal representation that would advise them appropriately. It depends on how severe the case is. There are so many factors. And just to note that there is now an Arbitration and Mediation Act that repealed the 1988 Act. So this is what regulates ADR in Nigeria currently. So what is arbitration? I want to look at a few of these methods very briefly. Arbitration is reference of a dispute to an impartial third party or parties who gives a binding decision after hearing both parties. So the law says that one arbitrator is enough, unlike how it was before under the 1988 Act. So you can just employ one person, but you can have more than one if the parties agree. And I think that is a good development because, of course, it will be cheaper because you have to pay the arbitrator. So if there are three, you know that you are calculating payment times 3, but then since it's one, I think that's just okay because it also reduces the time and the complexity of the case. And then it's usually applicable for commercial, technical, or complex matters. So when the matter is not severe, when it's not complex, when it doesn't deal with a commercial dispute, most likely it will go to the other methods. So arbitration is usually used for these cases. And people usually end up in arbitration because they have already decided, before, maybe while preparing the terms of, let's say, their contract, they might have stated there that if any dispute arises, they would resort to arbitration. And then some, it is after the dispute arises that they would agree to go ahead to submit themselves to an arbitral tribunal or process. And then there's something called court annexed arbitration. This is where the court mandates that parties go ahead to arbitrate first and then come back to the court to give a report. So the arbitral tribunal can make so many orders. They can order for the payment of a sum of money. They can order parties to do something or refrain from doing something. They can make an order concerning the specific performance of a contract. As long as it doesn't have to do with land, they can set aside or cancel documents. And arbitral awards are binding. They are binding and enforceable under the Act, and they cannot be appealed, although the award can be set aside. So the law states the grounds for which awards can be set aside, and you find that in Section 55 of AMA. The second method is mediation. Mediation is simpler than arbitration. It is when a neutral third party assists the parties in reaching a mutually agreeable solution. We listen to the expert on mediation that spoke before we started the presentation, where he said that you do not actually make an agreement for the parties, you just advise them. So that is what they basically do. They help them. They ask them what for the facts, and then they help them towards making an agreement, right? So, and you find out, there are many mediators here. I'm sure you agree with me that there are so many, like the compliance with the terms of agreement is quite high because, of course, parties agreed. So they most likely would do whatever it is that they agreed upon. And one good thing about mediation is that it helps parties to, it helps relationships, right? It helps relationships. When I spoke with the legal officer of a teaching hospital, she said sometimes after mediation, it is even the patients that will be begging for the doctor, please don't sack him, please don't sanction him, don't sack him, or don't do this, don't do that to him. We are fine now, everything is okay now, and stuff like that. That is the advantage of mediation. And therefore, negotiation, quite similar, but then for negotiation, there's a lot of focus on winning. Parties, the negotiators want to win. They focus on who has the better bargaining skills, who has more information, and it is usually those people that win such cases. So it is not really suitable for medical negligence cases because the trust between the parties will not be as high as for mediation. So mediation is more suitable. And then there's early neutral evaluation where parties will come together and then a neutral evaluator would tell them about the strengths and weaknesses of that particular case, advise them as to the values and merits of the case and how to move forward and go ahead from there. And so let's move to the benefits of ADR in medical negligence disputes. One is less technicalities. So it is often said that it's often said that parties that go to court do not leave the court with holding hands and smiling at each other. That's usually not the case. It is usually the fact that they keep on being bitter, they keep on fighting. So that's how it is with litigation. But then with ADR is, it's not like that. It promotes, sorry, less technicalities. So sorry about that. I was talking about something else. So usually in litigation, parties have to do a lot of things. They have to file motions. There are so many technicalities involved, right? So sometimes the cases might be thrown away because maybe the counsel to one party refused to file something he or she was supposed to file, or maybe filed something out of time, and then the case is thrown out. Sometimes they go ahead and after getting to a particular point, somebody raises an issue of jurisdiction, and then they have to throw the case away. They have to pause the case and handle that. And then when they are through with that, they now go ahead with the case. The lawyers here would know what I'm talking about. So there are so many technicalities involved. Apart from that, you have to look for witnesses. And sometimes it is difficult to get witnesses for medical negligence disputes because even for others that witnessed that particular incident, they might not want to testify, except, of course, they are mandated by the court because the court could also do that. The court could mandate them to come testify. And then even the expert witnesses are sometimes unwilling to come to the court. So, that could cause a lot of frustration for the parties, especially the patients that are probably ill or maybe, they just recovered and need to rest and all that. And then another advantage is less focus on liability. In litigation, there's a lot of focus on liability. You, of course, have to prove that the medical practitioner did something. So you have to, if you sue under the law of torts, because people could also sue under the law of contract, breach of contract, if there was a promise that was made, which is why medical practitioners do not promise anything. They'll tell you they'll try their best. They will not say, oh, yes, I promise that you'll be fine. No, they don't do that. So that you don't sue them under breach of contract. right? So and then apart from contract, you could also sue based on breach of fundamental human rights. But if you are bringing the case under medical negligence, which is a law of torts, you have to prove that there was a duty to take care, and then that duty was breached, and then the patient suffered a particular harm. If there is no proof of harm, if there is no form of injury that was suffered by the patient, you cannot bring a claim under medical negligence. But in ADR, you don't have to prove anything. You are there to settle. You are there to, so nobody is saying, okay, who was there when you did it? Do you have weaknesses and all that? That is not the focus in ADR. So which makes it better than litigation. And then it preserves the doctor-patient relationship, which is what I was talking about earlier. Parties come together to discuss. They live there smiling. They live there maybe as friends. They can continue their relationships. So, and then the doctor is not bitter. Sometimes medical practitioners will think, oh, with all my sacrifices, with all I've done for patients in the past, I make this simple mistake, and then they want my life for it, or they want me to compensate, or they are stressing me, and so on and so forth. And then hence what they make up their minds to become cold to patients. They tell themselves, I'm not going to empathize anymore, I'm not going to do this, I'm not going to do this, and so on and so forth. So ADR would not allow that. It makes parties to preserve their relationships. And then the impact on psychological and physical well-being. There's no way someone is sued and the person will not feel down. I mean, today you are in the hospital doing your job. The next day you have been summoned to come to court to answer to a particular mistake that was made, right? So there is an impact on the psychological and physical well-being of medical practitioners. There's no way they will not feel down, because of that. And this affects their work. They cannot attend to patients as well as before, and it takes a lot from them. But for ADR, they are not so scared because they know that, okay, this is, we're just trying to settle this issue. They don't suffer from psychological stress as much as, litigation. It's not as much as what litigation would do to them. And then for the another point is private sessions. For ADR is done privately. It's even possible that nobody knows. Even within the hospital, it's just possible that it's only the parties that would hear about the case. It's very private. No one, there are so many mediation sessions that have happened over the years. I'm not sure I know of any, right? Because of course I was not invited. So if you are not a party, if you are not the counsel, you are not the legal representative, you are not one of the parties, you might not know about such cases. So it's very private. And what that does is that it preserves the reputation of the medical practitioner, right? I know of some doctors now that, they were sued and all. I know their names, I know their hospitals. Most likely, I will not want to go there tomorrow to subject myself to their treatment or whatever, because I'll be scared. I'll be like, oh, they've done this to someone before and all that. So their reputation is on the line. But for ADR, well, there's nothing like that because you will not even know. And then for patients too, if someone is trying to hide a medical condition, for example, and then of course you go to court, that is out already because they know that, oh, this person has this, is suffering from HIV, oh, this person is suffering from whatever disease it is. So that is another advantage. Another one is speedy resolution. Some cases there's a case, Pawaya's case, where a child was transfused with blood, contrary to the consent of the patients. That case spent almost 10 years in court, if not up to 10 years. So you know how that would, in fact, the family members tried because most people would have withdrawn the case. Because the thing about medical negligence disputes is that it is either the defendant it is either the patient or the either the complainant or the plaintiff is sick or was sick and needs to recover, or there's a family member that was sick or that is injured or ill or something. So they do not want to keep going back to court. And that is what you get when you file your matter in court these days in Nigeria. They keep adjourning. The first few months, sometimes they adjourn, they keep adjourning, and this goes on and on. And then sometimes they need to conduct the case de novo. They'll start all over again, either because the judge dies or the judge is transferred or the judge retires. So this can take a long time. And delay is not easy for people, even the medical practitioner. Most times he or she would want the case to just be over so that they can go on with their lives. Some are suspended, some are suspended at the council. So until maybe some would want the case to reach a logical conclusion before they can continue with their practice. So imagine the case going on for 5 years, 6, 7 years. That would take a long time. But for ADR, I've heard of cases, mediation sessions that happen. I'm sure Simi will know what I'm talking about. 3 days, sometimes a week, and then they are done. They resolved everything. Sometimes even a day, right? For cases that are not very severe. So speedy resolution is another advantage. Flexibility of procedure, that's another advantage. You'll get to choose, for ADR, you get to choose your mediator, you choose the language, you choose the venue, you get to choose a lot of things. You have an agreement in place. Most times, if it's going to be formal, you can have an agreement and decide on what it is you want to do and what not you want to do. So there is flexibility in the procedure. Unlike what we have in litigation, you don't get to choose your judge. It's not possible. They will tell you that you don't have a say over who your judge is. You might have a bit of say over the venue, but it might not be the exact one. So it all depends, but it's not as flexible as you would have ADR sessions. ADR sessions are more flexible. And then flexibility of outcome is another advantage. Flexibility of outcomes or solutions. Solutions are numerous. It's not all the time that people want compensations, right? It's not all the time that they want to be compensated for what happened to them. Sometimes all they need is an apology. They just or maybe an explanation. Sometimes it could come in form of the resolve to change a particular narrative. The CMD, for example, could say that, oh, okay, henceforth, this is a procedure. We're going to change the policy in this institution so that nobody else will get hurt. Or sometimes, well, we'll change the procedure. This is this and this and this will happen. So there's flexibility of outcome. They can decide on a lot of things. They can decide on a lot of things. When I spoke with the legal officer I told you about, she said sometimes they can give people jobs. Somebody died, for example. She told me somebody died, and then the family, I think maybe 1 or 2 of the children needed jobs. The person that died was a breadwinner, so all they did was give these people jobs, to help them. So there's flexibility of outcome and solutions. Cost effectiveness. When something goes on for a long time, litigation, when it goes on and on and on, you keep paying your legal representative, you keep paying your lawyer, so it's very expensive. But when it is short and just for a period of time, it is not that expensive. And that is exactly the case with ADR. It is less expensive. You don't have to spend so much, especially when you just have one arbitrator or one mediator. And then it encourages open communication and disclosure. So people can explain. Sometimes all the patient would need is an explanation. What exactly happened? Can you tell me what even happened? What were you thinking when this happened? And then the doctor gets to explain. That might not be possible in litigation because it's even possible that the doctor is denying what happened and all. So the doctor might not even be able to explain anything. So these are the benefits of ADR over litigation in medical negligence disputes. But there are also limitations. And the first one that I will talk about is failure to deter. Now, when there is a severe penalty concerning a particular issue, it is very likely that people would want to fall in line, right? They want to be more careful because they know that if they do this thing, this is what is going to happen to them, and they will not like the outcome, right? So one thing about ADR is that for medical negligence disputes, people have stated, and I think I agree too, that when medical practitioners or healthcare providers know that, well, all that will happen to them is, we'll just settle now. We'll just settle. It's not like they do it deliberately, but they are less careful. So that is one disadvantage. Some would be as careful as ever, but some will relax. And this would lead to more cases, more negligence, medical negligence cases happening. Another limitation is lack of precedence. Lack of precedence. When I was talking about types of medical negligence cases, I mentioned some examples. That is precedent, right? Precedents are they are very important when we talk about the source of law, because what it does is that when there is a case already and another one comes up with similar facts, the judge will not have to be thinking of what to do. There is a precedent already, and all they have to do is to follow that precedent to handle that particular case, as long as the facts are similar. And then even those of us that are teaching too, you want to teach, you want to emphasize on a particular principle, the case will be there for you to talk about. But then for ADR, there are no cases. We do not have precedents, right? Because everything is done secretly, names will not, you don't know anything that happens. So that is another disadvantage. And then the nature of the dispute. Sometimes medical practitioners want to prove that they are innocent, right? They don't want to participate in ADR sessions. They want to go to court and prove that they were innocent. They didn't do anything wrong and stuff like that. So such cases might not fly when the medical practitioner is adamant and says that, oh, I'm not, I am not, I was not negligent, And then another one is complex medical facts, because some cases would involve so many complex facts and issues. And then it's also possible that there are several parties involved. So some of these cases, there might be some difficulties. They could also still go on to ADR. Excuse me, but then there might be some difficulties in resolving them through ADR. Another thing we should discuss is institutional readiness and appropriate representation. So we want to know whether ADR is going on in our healthcare institutions in Nigeria. And I would say yes to that. Because I spoke with someone, I told you I spoke with someone, and the legal officer of a particular healthcare institution, a particular teaching hospital. And then she told me that there is no written policy concerning ADR in their hospital. But because she knows the importance as a legal officer, she knows the importance. So when she receives any information on a particular case, she goes ahead to try to resolve it as quickly as possible. And then she told me that the CMD too is always usually aware and always encourages her to do that. So they do more mediation, definitely, because of course it's simpler and it doesn't take so much time. So they do more mediation, and they have been able to handle a lot of cases. She told me about some. One woman, for example, that was they thought she had COVID, but in actual fact she did not have, and then she was pregnant. So they abandoned her and refused to attend to her. And then she suffered a miscarriage. The baby died, and then her womb too was affected because they did not even carry out evacuation on time. And so, excuse me, they had to try to settle. At the end of the day, they paid for, of course, she was not charged for the treatment. And then because her womb was damaged, they had to help her try to get pregnant. So they handled everything. And then another case where they gave someone the wrong cups, and the person took the cups, the family members took the cups. They didn't check, they took the cups to a city very far away from where they took it from that particular hospital. It was until they got there that they discovered that they carried the wrong cups, and then they had to handle that. They apologized, and I think they paid for transport and stuff like that. And then another case of someone where rats ate the corpse. Rats ate the corpse. They also paid. They also paid. And then another case of someone, there was an emergency situation and the woman wanted to give birth. And so they threw the placenta while they were, because of the chaos and all, they threw the placenta away. And then the next day, they brought the police to arrest the hospital staff for throwing their placenta away. So what the woman did was just to try to, of course, she apologized and everything, and then she actually went to the bin to look for the placenta herself, and then she took it out and gave it to them. They complained it was not fresh, but then there was at least you have your placenta. So different remedies depending on the circumstances of the case. And so what I took from that particular conversation I had with her is that there is no policy, right? I wish I had the opportunity to talk to more people, more legal officers in other hospitals, but for that particular one, no policy. So it depends on the people there at that point. So if they leave at one point or the other, for example, it's possible that mediation will not be so rampant in that particular hospitals, and then they will just leave people to do whatever they like, those that want to go to court, those that want to resign to fate and not do anything, all these things would happen. Safeguards to ensure fairness and accountability. One is regulatory framework. There has to be regulatory frameworks. And thankfully, we have the AMA. AMA is I think it's comprehensive enough, but one thing is that it will not cover all aspects of ADR. There's no way it can cover commercial disputes or medical negligence disputes and all those things. So hospitals also have to come up with their policies to specify some particular issues that they would want parties to consider, right? So policies are also important apart from regulatory frameworks. And it's also important to have agreements in ADR sessions, especially for the more formal cases, right? It's important to have agreements. And then in the agreements, you state some things, the principle of confidentiality, for example, and so many other things. All these things will be stated in the agreement. So that way, it would ensure that there are standards. And then legal representation is important because when someone wants to do it alone without legal representation, the person might be cheated. Person might not might not leave the place with everything he or she is supposed to get. So it's always better. And then a legal representation, especially those that are more familiar with medical cases, they will be able to handle such cases better. So when someone is well represented, it's just like going to court alone without any form of representation. The lawyer would know better, so it's always better to go with a lawyer. And then awareness of ADR for chief medical directors, for legal officers, especially including those in private hospitals. So it's important that people are aware of ADR so that they know that, okay, this is an option, especially for those that own hospitals and the CMDs, the management of these hospitals. Let them know that that ADR is an option, right? So that they will not subject their doctors to pressure, to psychological trauma when they go to court all the time. Then trainings for healthcare practitioners. This is very important so that they would know the policies that you have on ground in the hospital, because there might be policies and then people don't know about it. So let them know that, okay, there are policies or there's a particular policy on ADR. Let them know the regulatory frameworks relevant to ADR. And of course, I think there should also be constant trainings on medical issues, how to relate with patients, the principles of consent, confidentiality, and patient safety, right? So that they know what to do and what not to do. And I would say that the Code of Medical Ethics talks about recurrent medical negligence cases. So cases like that would also be an exception, I think, for ADR, because if we cover up such cases, somebody in 2020 is maybe sued or goes before the tribunal, right, for medical negligence. In 2022, something else happens. This same person harms a patient. In 2023, the same thing happens. I think ADR will not be suitable for that because the person could end up killing people, right? So it is important that there is a balance. For somebody that keeps harming patients, something has to be done about it. It has to be reported to the disciplinary tribunal so that they can handle such cases, and if possible, if the person's name has to be removed from the register, so be it, because it shows that the person lacks competence, right? So that is an exception for ADR. In conclusion, litigation is designed as a win-lose outcome, right? Somebody said it is based upon a war model. Like it's like you are fighting, you're at war. There's nothing like relationship between you. You are bitter against each other most times. Whereas ADR is different. So ADR should be promoted so that many cases will be resolved quickly and efficiently instead of putting patients and medical practitioners instead of making them undergo psychological stress. ADR should be used more. It might not be it should not be cast in stone, right? I don't think there should be any regulation saying that ADR should be the only option. I think we should throw it open and let people decide. But ADR should be promoted because it is very, very beneficial to medical negligence disputes. Thank you.
Thank you so much, Dr. Olusegun. All right, so please let's give Dr. Olusegun a round of applause. With our emojis, really, personally, I've enjoyed this session because you first exposed how medical negligence is probably not what we think it is. And that really set the tone for the conversation and how we understand it better now. I was really fascinated by some of the stories, the medical negligence stories that you had. Those, would be the stuff of movies, but apparently reality can sometimes be stranger than fiction. Thank you so much. Thank you so much, Dr. Olaito. Thank you so much. So
Thank
now
you.
we'll be moving on to, okay, ma. We'll be moving on to Dr. Aibe Greg. He's our second speaker today, and I'll be reading Dr. Greg's bio now. So because I cannot pronounce Dr. Greg's surname, I'm just going to call him Dr. Aibe Greg. I hope you don't mind, sir. Okay. All right. So Dr. Aibe Greg is an experienced arbitrator and mediator with over 15 years of practice in alternative dispute resolution. 15 years. Wow. Specializing in health sector, life sciences, and family disputes. He has been actively engaging in ADR practice since 2009, and he is a fellow of the Chartered Institute of Arbitrators, North America branch. He is the first Nigerian medical doctor to successfully complete the accelerated membership and fellowship examinations of the Chartered Institute of Arbitrators, United Kingdom. We have a first here, Dr. Greg is a Center for Effective Dispute Resolution, United Kingdom accredited mediator, and the first Nigerian medical doctor to attain this accreditation. We should be having some applauses in the chat section. He's also certified in online dispute resolution by ODR Europe and the Lagos Multi-Door Courthouse, and he is a member of the Lagos State Panel of Neutrals. His mediation experience is extensive, particularly within the health sector. He has handled over 100 ADR cases, including more than 50 mediation sessions concluded at the Lagos Multi-Door Courthouse. Dr. Greg serves as a faculty member of the LMDC's mediation skills training program, and is a frequent speaker at ADR workshops, advocacy meetings, and professional development programs. In addition to practice and training, he conducts research on the role of ADR in medical malpractice and negligence claims, and has served as an investigator on ADR-focused research projects addressing public health malpractice and dispute-related mechanisms in Lagos State. He is the founder of Medical Dispute and Conflict Resolution Limited, MDCRL, and an organization dedicated to advocacy, training, and capacity building in mediation and dispute resolution within the health and life sciences sector. Ladies and gentlemen, I feel like if you can stand, you can stand. But if you can't, you can also use the chat button and, give a round of applause as we welcome Dr. Greg to the virtual stage. Dr. Greg, the stage is now yours. Thank you.
Thank you so much for a very kind introduction. Almost embarrassing. Thank you. I want to congratulate Dr. Olusegun Lighton for a very powerful presentation. She's an erudite scholar, and I'm not surprised in any way, shape, or form. I also want to congratulate Barrister Simi Owoye. I call her Simi for what she's doing. She's doing a wonderful job in this space, and we need something like this actually um, to be able to coordinate efforts in the ADRO landscape and be able to create collaboration. I can see in the list of attendees some of my colleagues and friends, and I send my warm greetings to them all. So today, Dr. Olaiton has done a lot of work, so I will try and just de-emphasize the part where she has talked a lot so that I can keep to time. And I want to talk about these four topics, although they're supposed to be taken in individual presentations, but Simi has thought it wise in her wisdom to put everything together. These are topics that I can talk about for a whole day if I take each and every one of them, but I'll try and compress. So I've designed my slides in such a way that dedicate like 60 seconds to each slide. So I have about 25 slides so that I'll be able to finish within 25 minutes. But during question and answer session, we'll be able to elaborate and talk more about different aspects that we need to clarify. And so patient safety and public trust is what we'll look at. At first, I'll look at accountability without fear or defensiveness. Then we'll look at system learning from medical errors and the role of ADR in improving health outcomes. This was one aspect. This last part, Dr. Olaito Olusegun did a lot of work, so I'm going to de-emphasize it. She did a wonderful job on this. I'll just focus on the top three aspects that she mentioned. I have nothing to disclose, apart from the fact that this particular logo you see here is a registered trademark of medical disputes and complete resolution limited. So if you want to use it for anything, you have to seek permission to do that. Other than that, I have no other thing to disclose. So, well, first of all, let's talk about patient safety. My background is in obstetrics and gynecology. For full disclosure, I still practice. So I'm not just a armchair obstetrician gynecologist who sits down and I do ADR alone. I spend probably maybe 10-20% of my time on ADRO, maybe 60-70% of my time on research, and maybe 30% on practice. So that's how I distribute my time these days. It's my professional time, I must say, because there are other things I do other than my professional life. So patient safety is very key to all of these things that we are discussing, and that's why I'm coming in. From my experience as a practitioner and the provider myself, I noticed that everything starts from patient safety. If patients are safe, there will be no need for ADR, there will be no need for litigation. But the truth of the matter is that patients are not really safe, and we want to look at those reasons why patients are not safe. And the reason why patients are not safe is not tied to an individual provider or practitioner. It's tied to the system. And that's why the Joint Commission, an organization based in the United States of America, defines patient safety as a systems analysis of medical errors that maintains individual accountability and minimizing individual blame. So if we want to evaluate patient safety, as it were, you have to analyze patient safety in terms in the light of medical error, in light of accountability, while you minimize individual blame. That's by the Joint Commission. The Joint Commission, like I said, is a non-profit organization based in the US. So, what are the national safety goals? Why do we emphasize safety, national performance goals? This was also put by the Joint Commission. Let's look at this from the perspective of right patient and right care. So, the fundamental thing about patient safety is that a particular patient X is that patient receiving the right kind of care. That's the first thing. Like I tell residents that I train resident doctors. The first thing I tell them that no doctor intends to go out to do harm. Doctors do firstly when they have the wrong assessment of the patient. So assessment is so key. If you evaluate a patient correctly and you know what to do for that patient and you do it properly, you're likely going to ensure that the patient is safe. So that's why it's a system thing, not individualized. So if you fail in any of these um, breakdown of activities, evaluation of the patient, that is getting the right diagnosis, giving the right kind of care and the right follow-up, patient safety will be compromised. So just put it in that perspective. So when you see cases of alleged medical negligence and then cases get to court, patients are disgruntled or dissatisfied, it's because along this line of care, something has gone wrong. So everything starts from the evaluation of that patient in terms of the diagnosis, in terms of the care. Let's give an example of a patient who comes in with case of preeclampsia. Preeclampsia is a medical condition in pregnancy, it's elevated blood pressure and proteinuria. And the doctor fails to make that diagnosis because it can manifest in some patients without showing elevated blood pressure. The patient came into the evaluation care, blood pressure was not really elevated, not so high, and there's just mild proteinuria. And the doctor discharges that patient home or does not give the patient proper information. That is the beginning of calamity. The next time you see that patient will be the emergency room, patient must have fitted, had seizure. And when the patient with preeclampsia, sees it, goes into a condition where the patient has started having seizure, the likelihood of survival is very, very poor. About for 50% of patients who have multiple seizures will likely not survive. So you can see that started from the very first time that the right diagnosis was not given to the patient. So I just want to understand the perspective that the doctor goes out of the way to make a wrong diagnosis and all of that. And this can happen to any doctor. As you grow older, you become more experienced. That's why there should be systems. Not emphasize systems. There's no perfect doctor. It's systems that make doctors good. So there could be it's another aspect of safety with medications. That every type of medication, if a patient, make a doctor has made a diagnosis for a patient, and the patient does not receive the right kind of medication, probably in terms of dosing, probably from communication error. You didn't write it properly. You added 1 0 instead of saying 1.0 milligram. You added 10 milligram, so you can overdose the patient. So these are issues with medication. The issues with infection prevention also. You don't give right to the right proper hands hygiene. There's a study that showed that 90%, 90,000 cases in 1 year of patients that suffer mobility and mortality, resulted from doctors not having proper hand hygiene. That's serious. 90,000 cases of mobility and mortality in 1 year came from just the simple fact that people did not wash their hands. So these are issues that are very important. And that's just one aspect. That's the most basic aspect of infection prevention. Of course, there are other aspects. Another aspect, which is not so common in when I say in our environment, I have to use that word carefully because I'm tied between two environments now. So in the environment, in some environment like environment in Nigeria, we don't have this issue of safety alarm. Safety alarm is when you go to the hospital, when you have those dingy things you hear, ting 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 ting. So those are a lot of alarms. Now in developed societies, if you practice developed societies, you realize that a lot of things have resulted from this clinical alarm safety. So the alarm, you get to the hospital environment like the ICU or high dependency units, you realize that alarm is everywhere. So you don't know which of them is the alarm that you're going to attend to urgently or the one you are going to postpone. So nurses or practitioners, at the end of the day, they ignore important alarms because they just feel as if, we hear it. They get so used to the alarm, they don't respond to it any longer. And that resulted in a lot of, catastrophic consequences for patients who practice in very developed societies where everything is based upon alarm. I remember when I was training in Japan, when you go to the labor ward in Japan, you won't see anybody. You just see patients in the labor ward, but you see the nurses seated by the side of monitors, just monitoring the fetal heart rate of the baby, monitoring the maternal heart rate. Once in a while, they will go there and conduct examination. In that kind of setting, you discover that if you are depending on alarm and you don't get the right signal for the alarm, the patient can develop catastrophe and you will not know about it. But that's not very common in our environment because many centers don't even use alarm. Those that use, minimize it. But the issue of health equity, some people don't even have access to the healthcare in the first place in terms of having the opportunity, the resources, or the ability to seek healthcare, and that becomes a challenge, as it were. Then there's also the aspect of communication challenge. There's what in medical practice, there's what we call the closed loop communication. What does that mean? If you are communicating a prescription to a nurse, using phone, you should be able to ask the nurse or whoever you're talking to, or a junior doctor, to repeat, what you've said. For instance, if you're saying, I want you to give this patient um, 1,000 milligrams of paracetamol, and I want you to initiate IV infusion. I want you to start antibiotics. You ask the person you are speaking to repeat everything that you said so that you are sure that the information is correct. Another thing you can do is to transmit that information electronically so that person can go back and look at it. So I do that in my practice. I don't just talk to you verbally. I follow up with a text message or a WhatsApp message to let you know exactly what I want you to do so that it will be clear to you what I want you to do. There are issues that affect us safety, issue of staffing adequacy, and that's very common in our environment in Nigeria, for instance, where we don't have enough doctors, we don't have enough nurses. And this is a big issue. You have one doctor seeing 200 patients, at a time. I remember when I was practicing in one of the public institutions, I won't mention the name, but look at my CV, you may know. As a consultant in charge, I had over 300 patients. So there's no way I could see 300 patients throughout their life cycle of the antenatal. These are antenatal patients alone. I'm talking of gynecological patients, patients who are just coming for antenatal. And so what I did, I had to devise a way where I can pick out those patients who are at high risk. So when I come to the clinic in the morning, I had a team of about, I think, 7 or 8 doctors. Maybe 4 of them were senior level doctors, then the others were junior level doctors. So what I do, I go through everybody's case notes for the day and look at those that are high risk. Then assign them to the more senior doctors. Then those that are low risk are assigned to the doctors who are lower in the cadre, so that we ensure that the more experienced doctors are seeing those who are competent. Those are things I have to devise, because I realized that there's no way I could see 300 patients, all through the life cycle of their pregnancy. And I communicate this to the patients directly in advance that I may not be able to see you throughout all of you throughout this pregnancy. But if I'm not seeing you, that means you are doing well. If for those of you that I'm seeing, it shows that you are not doing so well. So you should wish that I should not see you. And the patients will laugh. So this is also very important to communicate to patients to understand the reality of the situation. So another aspect that is also very key is to be able to look at to ensure safety, to look at the standardized strategies. And I want to talk about this a little bit because that is where we have challenges as it relates to alleged medical negligence, or medical errors. We don't have standardized protocols in the climb in Nigeria, but in developed climes, in other places, you have an opportunity to also practice or to train really. I realized that you have standardized protocols. One of the things about negligence, if you look at the pillars of negligence, which she has thoroughly talked about, I've also looked at it a bit. You realize that one of the pillars is that the patient has been managed by level of care that is suboptimal. And the only way you can define optimal care is through protocols. I think that's the biggest challenge. In fact, the way we practice in Nigeria, every practitioner is at risk of suffering from or being affected by cases of negligence. Let me be honest with you. That's just the truth. That's the reality of it. And I speak as somebody who is still very involved in practice in Nigeria, and also somebody who sees these disputes when they come into play. Everybody is at risk. And that is one of the things that I think I've been talking to the relevant authorities when I was still with NMA. When I was in charge, I was speaking to the then president in NMA. When I was still in charge of things like this, and I was telling him that it's important for us to have standardized protocols, and that's why when we started doing it in our Society of Obstetrics and Gynecology, we started creating protocols. Under one of our senior colleagues, a very renowned professor. When we talked with him, he started encouraging us to develop protocols. And we did some, before I left, and then I think they are still working on that. So really, we discovered that without protocols, you cannot really ensure patient safety. That's why I'm emphasizing that. Because from protocols that if this patient has been managed according to the standard that is expected. No doctor goes out of their way to want to do harm to a patient, but if they don't use standardized protocol, you won't be able to tell if they've done the right thing. But let me just also emphasize there that the fact that you use standardized protocol does not mean that everything will go well. But you have something at which you can go back to and say, I did it according to the way that it should be done. I'll talk about that a bit later because this is where I think all of our problems we are having in Nigeria healthcare, the majority of it is coming from here. If you want me to reduce Nigeria healthcare challenges in terms of cases of negligence, that patients are suffering, I will reduce it to two basic things: shortage of manpower and lack of standardized protocols. That's how we summarize it. If you can address these two issues, you are going to reduce cases of alleged negligence a lot. If you don't do that, everybody is at risk. It's not like a good doctor. If you are conversant with social media and even it's everywhere, you realize that even some of the best hospitals are having trouble. So the best hospitals are being sued. It's public knowledge. Everybody, not because those hospitals they are not good, they don't have the equipment and everything. Just because they're not standardized protocols for people to execute. That's the basic thing. Then other ways we can reduce this in terms of surgical safety checklist. This is also has to do with protocols. So surgical safety checklist is a follow-up of protocol. If you have a protocol that says that you must follow surgical safety checklist, you will likely not fall into error. Okay, and electronic prescribing system is not too relevant for environment. I'll be honest with you. Yes, in environment like developed societies, you can have electronic prescribing system being an issue. But the first two items I listed in this particular slide are the two biggest issues we have. And the second one is actually a fallout from the first. Because if you have standardized protocol, you should be able to work with surgical safety. Then the third, if you look at this particular list, I'll take some time then because this is where all our problems are. 1, 2, 3, 4. The fourth item on this list is simulation training. You prepare for war in the time of peace. People are trained like 20 years ago and there's no updates on that training. Because a lot of things have changed. The pace of advancement in discovery is so fast. As a matter of fact, the textbook that you are reading now is actually 5 years dated, because what they're going to use to practice in 5 years' time, the research is going on right now. Right now, I can speak to that because most of my life now is in the space of research. What we are doing right now, the research work we are doing, like what you will see in practice in like maybe 10 years. So by the time you are doing that in practice, you are not even doing that, you are already like 10 years behind because there are new ones coming out, new policies are coming out. So that's how it works in these things, the knowledge. And the best way to update knowledge is through simulation training. I hope you can still hear me because I think my earpiece fell off a bit. You can still hear me, correct?
Yes, I can.
Okay, great, excellent. So this simulation training again is a fallout from protocols. If you have standardized protocols that says that after every 2 years, every medical personnel must be trained particular area, that again will reduce the cases of alleged negligence that's confronting. And this is very important because thing about negligence is not just for us as practitioners of mediation or dispute resolvers. It's really for us. Everybody is in danger. Everybody who lives in an environment where there are no standardized protocols, every one of us, we are all at risk. Either you or your relatives. If you go to the hospital, it can be anybody. So even the doctors have relatives who have been affected. So that's why we must all work together as a unit to ensure that we improve on all of this. I hope I'm not talking to the choir, as they say in church, because I don't know that I'm talking to people who are already doing the right things. Another aspect is communication framework. Okay, it's very important that we have the right communication framework. Again, communication framework is also a fallout of protocols. When you don't have standardized protocols, you won't be able to, in your protocol, you should state clearly, that you are going to have so and so method of communication. So that's how it works. If you don't have that in your protocol, you won't be able to follow it as it were. Okay, so what are the ways that clinicians can, sort this out? What are the things that clinicians can do, in terms of resolving this issue? Clinicians, like clinicians, I mean physicians, pharmacists, anybody who sees patients like clinicians. Okay, so your documentation is very key. Documentation should be accurate, should be timely, and should be objective. If there are physicians on this call, that's very important. You should document everything you do, because anything that is not documented was never done. I remember one of the cases I managed once, a surgery I did, and later they called me and said that so and so worried about the case. And I said there was no complication anyway. They were just asking me questions. They were asking me my thoughts. I told them to go back to the case notes, to the case file. They should pick out the surgical notes. Everything written in the surgical notes is what I did. That if I did any other thing outside that document, it's no longer useful. I can't claim that I did it. But if you see, you know, everything that I've written in the surgical notes, that is what I did. So I noticed that a lot of surgeons, because they are so much in a hurry, they don't take time to write their surgical notes. They just rush over their surgical notes. And by the time cases come up, they are saying that, well, I did this, but they say it's not your surgical notes, because you'll be tried by the notes. You'll be tried by what you've written. It's not what you thought to do or what you imagined you did. So documentation is so key. When cases of alleged negligence come up, by the time we get to the courts, you'll be judged by the case file. That's the evidence that people will look at to judge you. Very important that you take time to write out your notes, clinical notes, surgical notes. They're very important. I can share a bit of what I do as a habit. So when I finish my cases in surgery, I never write my surgical notes immediately. I take my time, review the patient again. I don't write it in a hurry. I sit down, reflect on the cases, and take my notes. Fortunately, the last time I was at home, I was opportune to do surgery in one of the public centers. I was very impressed that they now have an electronic way of documenting surgical notes. So you don't have to bother yourself about that. As you are doing your surgery, and immediately you finish, you can actually dictate your surgical notes into an audio recorder and ask one of the other doctors to listen to those audio recorders and document for you. That's what I did. I was very proud. This is a public institution. I'm talking about a private hospital. I don't want to mention names of any institution. Public institution owned by Lagos State government. I just touched down. I said, no, let me get to your theater, book some cases for me, let me do. And I was impressed. I said, well, what surgical? They said, no, sir, don't worry about it. Just tell us. So I said, okay, fine. I will dictate to you, you record it, and you put it the way I've said, so that you don't make any mistake. So these are all improvements that we can make in our own practices. If public practices can do that, and I was very, very impressed. So we should communicate the right. I talked about communication before, the closed loop communication. I won't talk about it again. I've said it, that communication should be the closed loop in the healthcare system. What it means is that you should be able to get a feedback on what you are communicating to the other person, a colleague or another cadre of staff that you are dealing with. And your communication should follow this acronym called XBAR. You should have the situation analysis, you should have the background, you should have the assessment, and you should have the recommendation. That's an acronym, this XBAR. So a team culture is very important in ensuring patient safety. Work with the nurses. The doctors have a very wrong perspective at times. Some doctors that, yes, doctor is important, but you must work with other team members. You must work with the nurses. You must work with the pharmacists. You must have proper communication line with them and respect their work also. Because if something is going wrong with the patient, it's likely the nurse that will be the first person to notice in the ward. But if you don't encourage the nurses, you don't speak to them properly, or they're not properly trained, it's a recipe for disaster. So we should see the care of patients as a teamwork, not for individuals. Then for institutions, institutions should adopt what we call the just culture policy. What is just culture policy? Just culture policy is the policy where whenever things go wrong, you don't immediately jump on an individual to blame that person. Yes, there's need for accountability, and there's need to find out what has gone wrong, but you are more interested in finding out how you can resolve the problem, not holding anybody to blame in particular. Accountability is not the same thing as blame. Okay, blame is trying to bring somebody down, castigate the person and bring the person to disrepute and judgment. Accountability is saying, I recognize that something has gone wrong. I recognize my action or my inaction in this, and I'm ready to improve on it. That's what accountability is all about. Okay, so it's very important to integrate things like root cause analysis into policies that we do, and we'll be able to find a way of tracking our safety metrics. Be able to look at maternal, I said maternal because I'm a obstetrician, maternal morbidity and mortality reviews. Okay, look at the cases that you manage. Reflect on cases, even cases that have gone well. Reflect on them and see things that you should do better. Reflect on near misses, okay? Things that didn't go badly, but you realize areas where things could have gone wrong so that you can improve. So these are areas you should be able to have a system where you go back, a feedback system to look at what you're doing. This is for those who are doctors in the house. Okay, you can look at this WHO safety checklist. I won't dwell on this at all. It's in the website, okay? You can look at it later. So we've talked about accountability a bit. Okay, what is accountability? Let me just throw more light on it. Accountability is a legal and ethical obligation of healthcare professionals and organizations to answer for their action. See, this is very important. Answer for their action, meet the five standards of care. You see, this is occurring again. Standard of care. To meet the five standards of care. So you see, this is actually occurring again. Okay, so it's very important. I'm bringing out my pointer. I hope you can see my pointer. To meet the five standards of care is very important. Everything starts with standards of care. Now, to accept consequences when those standards are breached, to say, okay, this is where things have gone wrong. How can I become better? What are the things I need to answer to? So why is this important? Accountability ensures that trust in the healthcare is maintained and protection of patients. Because if there's no accountability, everybody can do what they like and get away with it. Like Dr. Olusegun said earlier on, like I said, I don't want to emphasize on what she said. So there are mechanisms of accountability. One of them is hospital peer review process. We do that a lot in most obstetrics and gynecological units, particularly those that have resident doctors, who are trained resident doctors. Most of the places that work in the public sector, they train medical doctors, resident doctors. So we do what we call the review. We review all cases every morning. We have worked, you look at my paper, you look for these places. We review whether the cases are good or bad, we review them to find out where things could have gone wrong. And when things are wrong, we call those who are involved, we call them into accountability and try to make, even before anybody notices anything, we're already working on this. So it's very important that at that level to have also peer review process to do these reviews. Then the institutions to have corrective actions for every physicians or clinicians. If a particular physician or clinician has a particular attitude, you should find a way of correcting that person. It could be punitive. There's no punitive measure, because if you do that, you save the trouble of when something catastrophic occurs. Because most of the cases have had to sit as a mediator. I realize that it's the organization that starts facing the challenge. The doctor who has done the thing may not even be there, or they'll say they sacked the doctor. If there's no particular case, the doctor ran abroad. Of course, they can catch that doctor through the Medical and Dental Council, because the council writes to wherever you are working to, anywhere in the world. They are going to hold you accountable. So that is why management staff, leaders should be involved in corporate governance and clinical governance. Also, in this case, clinical governance, where they watch over the employees who work within their system. That's one way you can hold people accountable. Then, of course, you have the civil litigation malpractice lawsuits, which Dr. Lighton has talked a lot exhaustively, talked a lot about exhaustively. Now, I've talked about the purpose of accountability. I don't want to repeat it again, okay? But it's very important for us to ensure that standard of care is maintained, and it's important for patients who are armed to be compensated. You can't just tell the patient to walk away and it will be well with you. You have to put measures in place to ensure that it is well with that patient. Now, the reason why I'm talking about this, I won't dwell on this, but Dr. Lighton has talked a lot about it, is that accountability is what forms the basis for the pillars of clinical negligence. And that the pillars, a duty of care was owed, a duty was breached, and the breach caused an injury. Now, you cannot even say that you were trying to help a patient. I'll give you a story. There was a mediation I took. where the hospital was held accountable. They took the hospital to court because when the patient was brought into that particular hospital, the patient came in and asked the hospital to help. The hospital even treated the patient for free and didn't collect any money and just helped, but helped, carelessly, and just said, okay, don't worry, this is the best we can do. You can go to other places. When they filed their suits in court, the hospital that was trying to help was even taken, but they joined the three hospitals. Patient eventually died in the last hospital. But even the hospital that said, oh, let's just what we can do and help you, they also put them in the lawsuit. So I tell junior doctors, I even tell people who work in my practice, don't say you're helping a patient and you give the patient off-handed attention. If you want to commit to a patient, you commit fully, whether the patient is paying or not. Because the fact that the patient is not paying you does not exonerate you from being accountable. So you have to be very careful. If you say you want to help a patient in the hospital environment, once the patient comes to you and opens a case file and you register that name, you owe that patient a duty of care. And even if you patient did not pay for it and things go wrong, you can be held accountable. And like I said, for you to prove negligence, there must be damage. So, for instance, if a doctor mismanaged you and there's no evidence of damage, you cannot prove negligence on that patient. Okay. Two, if a doctor manages you and there's poor outcome, and the doctor adhere to the standard of care, you cannot prove negligence on that patient, on that case, or that doctor. You cannot prove negligence on there because the doctor adhere to the standard of care, which is why I'm talking about malpractice and maloccurrence. There's a difference between malpractice and maloccurrence. It's very important for us to understand this difference. In medical malpractice, okay, there's an omission by a physician during treatment of patients that deviates from accepted norms of practice. And this is very important. I realize that in some of the cases of medical negligence that I've managed or mediated over, some of these clients, they will come with experts from UK and US, and the experts will come. I'm telling you real life experience. I'm not telling you something, some of the cases that I've mediated. And the experts will say, based upon our standard of care in UK, this is what we do. Based upon our standard of care in the US, this is what we do. But, during the caucus session, of course, I listen to them during the open session. When I get to private session, which is confidential, one of the questions I normally ask them, of course, as a mediator, you cannot say anybody has a bad case or a good case. You're not an evaluator, particularly in facilitating mediation, except if you are doing evaluating mediation. But what is practiced in Lagos Multi-Door Courthouse is facilitating mediation. And that's what I practice even when I'm outside the Multi-Door Courthouse. I don't tell you what you are going to do, but I use questioning skills to ask you questions. So when I'm with them in private sessions, I will ask them and their experts, they're from the US. So I'll say, so this is standard of care in the UK, yes. Standard of care in the US, I'll say, okay. Do you know the standard of care in Nigeria? They become very confused. So in a way, I've not said anything. I just ask them a question, and that's what mediators do. You don't tell them what to do. So by the time you're asking those questions, even the lawyers with them, their counsel that are seated with them are beginning to think again, And I will just say, well, your lawyer is here. Your lawyer knows everything about negligence and what you need to prove. But this standard of care you are seeing is standard of care that you have in Nigeria. So the locality in which you practice is also very important. That is why when you are being tried for negligence, what they will do, they will call your peer, who is, if for instance, negligence involves the consultant level, they will not go and call a senior registrar, or let me put it the other way. If a registrar or a medical officer was involved in negligence and is being tried, they will not, when they are calling somebody to come and testify on what the person will do, they will not call a consultant to come and testify. They will call your peer, somebody who is at your level, to say, will you act in the same way? Will you do it in this particular way? The person will say yes or no. And those are the things they take into consideration. They will look at standard of care again. I've emphasized this a lot, standard of care. And I'm sad to say that in many instances, we don't have protocols. When you don't have protocols, it's difficult to define standard of care. And that's where we have the biggest problem. That's why I emphasized that in the beginning. So it's very important to understand that malpractice is not the same as maloccurrence. Medical maloccurrence, it's an undesirable outcome. Yes, the outcome is bad, but you've done everything according to the books. So there are cases where you may have maloccurrence and not malpractice. So it's not every time something goes wrong with the patient. I'm happy that Dr. Olusegun emphasized that you say the doctor has done wrong. Doctor may have done everything right, but things still go wrong with the patient. and the doctor is not God. So things can go wrong. What is important is that you are doing what is right and you're communicating with the patient and you are doing everything by what you can do. There are certain things you can do more if you're outside a particular locality, but within the limits of your locality, there are things that are not available to you. For instance, postpartum hemorrhage, that's when the woman bleeds heavily, and it's one of the probably the number one cause of death of women when they have babies. And you are managing postpartum hemorrhage in Nigeria, the options that you have are quite limited. You are doing uterine artery ligation, or you are doing internal artery ligation, which is even a very rare skill, or you are doing what they call a village suture. You don't have uterine artery embolization, which is a radiological technique. So if you go and bring any expert and say, why did they do uterine embolization? That person is just a joke because that's not available to you. So you have to be judged within what you can do within your practice. So having said that, we have responsibilities upon the caregiver and upon the institution as it were. But to be able to show transparency in everything that they do, let the patient know your limitation. Let the patient know and you know your limitation. Don't gamble with patient's life. At every point in time, try and do what is in the best interest of the patient. At every point in time, if you have any doubts, when they call me at times, particularly in my own practice, and they say this and this, I've just said that refer this patient immediately and get a feedback on the referral. It's not because you cannot do what you are doing, but if things go beyond that, can you still do it? So you must be, if you are taking in a patient, you must be ready to go the full length of that. If I anticipate I'm going to deliver a woman prematurely, that's the time for me to refer that patient. If I don't have facilities for neonatal care, it's not when the baby is out, I start running around looking for ambulance. So these are many things that we can do. Also, we must be transparent. That's what the duty of candor is. To be plain, to be truthful, and to tell the patient your limitations. Don't paint your hospital as Alpha and Omega, can do everything. And meanwhile, you have limitations. So be aware of your limitations. That will help. Okay. Also, build trust. And these are all the things that can reduce litigation, and promote early resolution of cases. I want to talk a little bit about system blend. I don't know whether I've gone beyond my time. I want to try to finish within the time limit. Okay, I want to talk about system blend. System blend is quite important. I think that's where I'm going to, yeah. And but before I talk about that, let's talk about the second 50 phenomenon. Many times when there are cases of alleged negligence, we think that the doctors they they are not sober. In my experience, in cases where I've mediated and in places where I've been involved, the doctors are very, very sad. Most of the time, over 99.9%, you see doctors, some of them go into depression. I've had cases where doctors become suicidal, from cases of alleged negligence. Some of them become suicidal. I remember one doctor, one case I managed, the doctor is even a foreign doctor, but the doctor just took off and became depressed and closed the practice. Eventually we were able to resolve the issue, at the end of the day, out of fear, because of threats and so many things. And we must understand that cases of alleged negligence comes under the boundary of tort law. And then tort law, the lawyers are here, they can correct me. These are not yet criminal cases. These are things that are what they call tortious liability. So, but at times when you have cases of alleged negligence, they want to criminalize the doctor. They want to even kill the doctor. And so these are things we should look at. It's not very safe in our society. What does that lead to? It leads to defensive medicine. So people don't want to take on cases that they can even manage. You can manage the case, you can help the patient. But you're afraid, say things go wrong, they won't be accountable. So you refer unnecessarily. Cases that you could have managed. You've heard of cases where they took a particular patient to a hospital, the hospital said, refer, it didn't do anything. Because they don't want to be held liable. That's what happens in society where people, there's a lot of pressure on people, which is okay. It's okay for people to be held accountable, but you also must draw the line when people are trying to do the right things and they must do it the right way. I'm not saying that doctors should not be held accountable or hospitals should not be held accountable, but we must also be fair and sincere in prosecuting cases of alleged negligence. If you look at the case dispassionately and without sentiment and see if things were done right or wrong, the fact that things were done correctly does not mean that the outcome will be good. Okay, so these are some of the challenges that people may have. Okay, so people run away from high risk cases. Then people also will overtest something that you can check with X-ray. You You want to do MRI, but you want to be sure that you're not missing out on anything. And that will add to the healthcare cost. That's why you go to the hospitals, they will tell you that they want to do MRI, they want to do everything because they don't want to get into trouble. So we should be able to shift from a name, blame, and shame approach, okay, to accountability-based system. Accountability does not mean that you're not holding the person responsible. It means that you are willing to help the person improve also, okay? And so you must understand that clinical negligence also creates an opportunity for people to learn and improve from reckless behavior, okay? For people to improve their practice, that's where the learning model comes about, okay? You look at it from a very, but just model, I mean, you look at it from a very clear perspective, you find out where the problem is. You use a system-based approach, not individualized approach, to find out what has gone wrong. And let me assure you that for every case of negligence that you see, it's a systemic failure. It's not an individual problem. It's very rare to see individuals who will just engage in persistent cases of reckless behavior clinically. Most of the time, it's a system failure. So we should work on improving our system. And like we realize, one of the biggest challenges we face in Nigeria right now is that they're not keeping our doctors. It breaks my heart to see the number of doctors that we train. They have all left the country. Who's going to manage the patients at the end of the day? And the reason why doctors leave is that if you look at, I don't want to talk about this, is not the event talk about this kind of thing. If you look at what doctors remuneration that doctors get in Nigeria compared to what they get outside the country, my prediction is that in 10 years, we will have no doctors to take care of people in this country. I'm telling you the truth. Because the last set of doctors who stayed back, they are getting to the age of retirement. And all the young doctors who are being trained right now, the same thing with nurses, not just doctors, they're leaving the country. Because Nigeria spends a lot of money to train medical doctors, almost for free, at least in the public hospitals, like I say, almost for free. And we just let them go out for nothing because we don't have a mechanism of retaining our doctors. So they go out of the country without training, they cross the border, they write one exam, and they are earning 20 times their salary. If you have a child who studies medicine, you encourage the child to stay. That's the question I ask people. Some places you don't even to do any exam. You just walk away and you get into another country. Even Gambia pays their doctors. Gambia, that we are richer than, pays their doctors far more than they pay doctors in Nigeria. So we're going to have a lot of problems in the next 10 years. I'm telling you the truth. I said it 5 years ago that cases of negligence will increase in Nigeria. Even if you like, build the best hospitals, buy the best equipment, who's going to manage the hospital? Who's going to stay? Where are you going to get them from? Okay, you bring those from abroad. How are you going to pay them? How will you retain them? It's beyond even money. How are you going to give them the right environment to practice? So those are the things that we are facing in our country, and it breaks my heart a lot to see our country, the health system deteriorate so much, and you don't really know what to do. At times, I just feel like crying because I know we are all at risk. Every now, there's no day I don't get calls from Nigeria about this is happening, that is happening. What do we do from doctors, from patients, from relatives? And the doctors that are coming on right now, the training is not as good as it used to be because the people who are training them are even leaving the country. Those who are supposed to train them, they are poorly motivated, who are left. So we have a crisis in our hands. And I hope that what I'm saying this is that we should use a system-based approach to reduce cases of alleged negligence. Because it's not about, even if you win a case in court, can you bring back a life? Can you bring back a life? You win a case in court. Can you bring back a life? There's no compensation. That's what I say in my mediation. There's no compensation you can give to anybody that can bring back a life that is gone or a limb, as it were. So the consequences of negligence is catastrophic. It's not like a house that is burnt. It's catastrophic. It's permanent and it's forever. And that's why we must have, a system-based approach instead of looking at individual cases. We should build our system. Two things I want to leave with. I want to say how much. Okay, I'm almost done. Yes, I'm just forwarding my slides. Okay. So, two things I want to leave with us and emphasize is about standardized protocols. I don't know that I'm talking to the right people, but it's very important. One of the things I tend to do a lot when I get back to the country, I want to work on building systems, not helping one doctor at a time. Building systems that can last, and the way is protocol. That's the way to go. Let people work by the protocol. Protocol is not perfect, but at least you have something to hold on to that you can work. So we must look at root cause analysis, which is what I'm talking about. Root cause analysis is finding out why we are having cases of allergies. I just told you the reason. It's because we don't have standardized protocols, and we are poorly, our people don't maintain training. There's no retraining of our healthcare personnel. Okay, so I won't talk about this at all. This has been taken by the earlier speaker. Okay, and she talked a lot about how they are improve our healthcare outcomes. Okay, and so I won't talk about it again. She has mentioned this, so I don't want to go about it again because she talked about it. But I want to talk about this. This is my last slide. So many years ago, 2015, this was a model I built in 2015. I was looking at a way where we can put more ADRO into our healthcare system because as it is, it's mostly limited to mediation. I know Solution said many things that mediation is simple, but it's not as simple. You know, there are mediations that may take 1 year, depending on the complexity of the case. You know, so people think that mediation is the easy way out to arbitration. It's not true. If you practice mediation, you know that it's not as easy as it may be. Some cases are simple, but some cases are actually not very simple. They're actually very complex. But it's also as it's but overall, in the overall look of things, is it takes a shorter time than litigation, you know, and it's less expensive in the overall look of things. But some cases can be very complex and can take a very long time. So this was the model I built, and I'm still trying to work with it. The dispute, medical dispute chain, you know, when you have disputes, how do you go about it? In my experience as a mediator, you know, I realized that this is where the problem is. They don't engage, parties don't engage on time. You know, and I'm happy with one reference that Dr. Olusegun gave, that the legal officer of a particular hospital, you know, tried to engage. What she's doing is that she's engaging really. You know, she engages on time. That's why she's able to resolve those disputes early. The essence of engaging the patient is not for you to cover up. That's why I emphasize accountability. Accountability, yes, people should be compensated. One of the things that I want to emphasize that she talked a little bit about, but I want to emphasize it, is that the beauty of ADRO in healthcare disputes, beyond all of the things she said, is that parties are able to take responsibility of the outcome of their disputes. That's very important. At times, there's a tendency for people to feel as if I go through ADRO, or maybe I will be able to bring the hearing party to book. I will be able to punish the doctor or punish the hospital. It's not true. You can actually determine the kind of punishment you want for them. Because like I said, most cases of alleged negligence are still within the realm of tort. So it's not a criminal case. So at the end of the day, when you get to the courts, they'll still give you compensation. It's not likely that they are going to sentence the doctor to death because of alleged negligence, except if it was a criminal case. You know, if it's not, they will sentence the doctor to death. So it's still compensation that you still get. And so it gives a good room for ADRO to come into play, because in ADRO, people still get compensated. I think that would be a question that will come on. Maybe I don't dwell on it. But what I would emphasize is that engaging early is very important in talking to the patient. You can also negotiate. I think that legal officer you mentioned does that repeat. You know, talk to them and see what they want. And at times, it's not every time that the hospital is guilty of anything. It's just explanation. Just explain, this is what we do here. This is why we do this way. This is what led to this. So you can even get that at the level of engagement, even before you get to a negotiation. And if you feel like something is broken, you can negotiate a way out. But of course, you can mediate, which is most of the cases I do for mediation. I have never done any case of arbitration from negligence, but you can get commercial, you know, and all of that. So I think I will leave it at that so that we can take questions and all of that. Thank you so much.
Thank you so much, Dr. Greg. It was really insightful. I like some medical terms that I'll probably use for my friends in the medical field later. And I also learned a lot of other things, especially standard protocol. I think it really also talked about what Dr. Olaito has said about how medical negligence is also proves it's that whether the doctor has done what they should do. So if those standardized protocols are available, then we can be able to say that negligence has happened or it hasn't happened. And I also liked how you addressed it even from the ground up, how that the doctors that we currently have, the trainees they're currently getting, the number of doctors assigned to a number of patients to doctor ratio as well. And I like the bird's eye view of how negligence happens and even how they can be solved, especially because the compensation you're going to get would not bring life back, would not bring the limb back, or would not bring the intestines that was cut away back or anything like that. So really, 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 really thankful for this session. So because we've already overshot our time by a mile, we're just welcoming about 1 or 2 questions, but we already have one question from the mail that I'm just going to read out. Either of our speakers can just take that question. And then if you have any other question, please put them in the chat box rather, and then we can have that and then be off the webinar. So the question says that the person said, I would like the speaker to speak on medicated negligence related to wrong administration of drugs, chemo, incompetence of surgeons that perform operations, improper planning for complications after operation, and side effects of chemotherapy that led to the death of a child and a pregnant woman. How can ADR be used to resolve this dispute of criminal matter? So the person has already framed the thing as a criminal matter, which already limits it because ADR cannot be used in criminal matters. But I would still want us to still comment on that still. Maybe Dr. Lighter can go first.
Yeah.
I think, thank you very much. And thank you for the question. I want to thank Dr. Greg. I would also go with the first name to be safe. I want to thank you for that very wonderful presentation. I actually learned a lot. And it really pains me, many of the things you said, I felt very sad. And some of these things had been on my mind a lot, especially with the doctor-patient ratio and the situation with the country, systemic faults that lead to negligence and all. But concerning the question, I think Dr. Greg mentioned talked a lot about that particular question. So I think he is in a better position to answer, but I would just say that even though under the law, criminal matters should not be taken by ADR, it still happens. It still happens. Sometimes, when medical practitioners, when someone dies as a result of medical negligence, it is usually referred to as manslaughter, not murder, because of course, no one, just like Dr. Greg said, no one actually plans to kill someone. There's no doctor that goes to the hospital to say that today I'm going to kill 2 people. No, they don't. It's usually born out of a mistake. So that's why they refer to it as manslaughter, right? So most of the time when this happens, they still, because they know, they acknowledge that, of course, it was a mistake. Many of them still undergo mediation. I know some examples of, I think I mentioned one where someone died and then they were able to, they begged, went to the family house and talked to them. I think they involved the palace and some elders in the community and all that. And then they gave some of the family members jobs and all. So I think Dr. Greg can continue from there. Thank you.
Okay. Yeah. So now that's a very good question because it was like a mix of so many things. Now, I know the lawyers here can correct me. I think there are a lot of lawyers here. In criminal cases, I think the burden of proof or the weight of proof is you have to prove beyond all reasonable doubt. Is it not?
Yeah,
Yeah.
criminal matters.
So one of the things that people do when they have cases of alleged negligence, you just rush to fight criminal admission. I don't know. It's a difficult case you can win in court, but that's for the debate because you have to prove beyond a reasonable doubt that that particular practitioner, I think second degree murder, that's what they will call it, maybe in the US, because it's like under manslaughter, which is equivalent to manslaughter in our own climate. I don't want to go into an area where I'm not an expert. I'm not yet a lawyer. But having said that, in ADRO, it depends on what, like I still believe that through ADRO, you can get what you want and you can determine the outcome of your dispute. Because if you take that particular dispute to court and you are not able to prove beyond all reasonable doubt your case, you lost that case. And you go back again and you start afresh, and the families cannot get closure. But in ADRO, you can determine what you want. I'll give an example. There was a case I mediated at the LMDC, or of course, I'll withdraw all of the particulars. At the end of the day, what the family wanted was just for the hospital to improve. So they put a lot of conditions and say, look, the hospital should buy so and so equipment. The hospital should ensure that they train so and so doctors and send them so abroad. So it was in the clause. So you take control of your disputes. Like our elder, Engineer Shingo said in that intro, that it's not for you to tell them what to do, even as a mediator, particularly in facilitating mediation rather, which was I was trained at, in my own training. I don't do evaluating mediation. You really don't tell them what to do. So parties can really come to the table and say, these are the things I want. Of course, you may not get everything you want, but you may get some of them. But at least you are in control of your dispute. But if you are so angry, you think everything is a criminal case, you want to carry the doctor, at the end of the day, you get to court. And I think lawyers that are here to advise their clients and look at cases. That's some other things that I also do. You can evaluate cases and see whether your chances of success and what you are suing for you can achieve. Okay, so it's very important that you, as a lawyer or as a client or whoever is affected, that you can work together, not with sentiments, and look at how this case is, really, and determine if it's something that you can get what you want. But in ADR, you can get most of what you want. You can determine the pace and what you want. So there are many avenues, many remedies, that you can put in place. Some have said that they should some take the cases to the Medical and Dental Council already, and in Medical and Dental Council, they also have their pathway. It's still at the level of a magistrate or high court. So they have their own way. I think high court level.
High court.
High court. Yeah. So they have their own pathway for resolving issues too that may not necessarily get to where you take it to, like a criminal allegation as it were. And I've also mediated in cases where the matter was already in council. As part of the draft in our settlement clause, settlement documents, we drafted that in council, irrespective of the outcome of what council is going to say in that dispute, that the parties want this and this to be done. That is the beauty of ADRO. Even as part of our draft, we acknowledged that the case was already in council, and the plan was to withdraw the case from council, but emphasize that council should ensure that this is this and that. It was also in the mediation, settlement documents that we got out of it. So there are many ways you can remedy things. That's the beauty of using ADRO. But if you take that case to court, you say it's a criminal case, it's going to be difficult to prove criminality. It's possible, difficult to prove because it's going to be beyond all reasonable doubt. And that may not be so easy for you to prove in court. And if you win in the first court, go to the appellate court. From the appellate court, you go to the Supreme Court. And closure for the parties will take a very long time. So I think I will just leave it at that. So my point is that to the punchline I want to conclude with is that people underestimate the power of ADRO. And the selling point is that with ADRO, you can take control of your disputes, except if your goal is for them to kill the doctor, then ADRO cannot help you. But if your goal is to remedy the situation, your goal is to ensure that the doctor is punished, ADRO can still help you to some extent. Because if you can sign the clause and say, okay, even though this case is in council, we want a minimum of this and this, if the people can agree. So there are a lot of ways. That's the point I'm trying to make. I'll leave it at that because of time.
Thank you so much. Thank you so much, sir. I think what I would take away is that even though it is criminal, ADR is still very much useful. There is so much you can get with ADR that you will not get with litigation. And that brings us to the end of the Neutrals Nuke this evening. Really want to thank everybody that stuck by with us. Really want to thank our speakers. Thank you, Dr. Olusegun Olaitan. Thank you, Dr. Greg. And yeah, that's the end of episode 3. I'll be handing over now to Miss Simi Owueye. Thank you, everyone, for sticking by. Miss Simi.
Thank you so much, Ayofe. Thank you for a well-moderated session. Thank you so much. Thank you
Thank
to our
you, Ayofe.
speakers.
Thank you.
Yes, you did so well. Thank you for
Yeah.
our speakers. It was a rich session, I must say. I'm very grateful to Dr. Olaito Olusegun and Dr. Aigbe Greg. Thank you very much to everyone who has attended today's session. This session will be uploaded on our YouTube channel, so we encourage you to please subscribe. Thank you for attending episode 3 of the Neutrals Nook, and we will be keeping you updated on our other episodes by following our social media platforms. Thank you, and have a
Thank
nice
you.
evening, everyone.
You
Thank you
too.
very much.
Thank you.